All right, good morning, everyone. Welcome to the Tuesday meeting of the House Judiciary Committee. We've got 4 bills, I believe, on our agenda today, and what I'm planning to do is take Senate Bill 120, which is Judge Crosby's bill, and probably have that heard first. I know we've got someone in the audience who would like to speak. And also, first, I want to recognize our judges here, Judge Boyette and Ms. Gosling. Judge Gosling, excuse me. Glad to have both of you today with us. No one else that we've missed in the audience, is there? Very good. 120, House Bill 120 is the matter dealing with the probate courts and the ability to have a prosecuting attorney employed for the purpose of prosecuting cases, criminal cases in probate court. Judge Crosby's bill, he is not here, and I think, Mark Middleton, you wanted to speak on the bill, and I know it's a measure that comes as a part of the probate judge's council recommendation. Why don't you come up and let you talk on behalf of the bill for Judge Crosby's absence. His wife, I understand, is in the hospital, and
yes, sir.
He's not able to be here today. So
yes, sir. Well, I appreciate it. I'm Mark Middleton. I'm here on behalf of the Council of Probate Judges, and I appreciate you letting me speak on the Senator's behalf. This bill came out of subcommittee yesterday as a substitute that was agreed upon by the district attorneys and the ACCG and of course the probate council. Much of the bill you'll recognize from a bill last year that this committee passed, allowing for solicitors in the municipal courts. This bill is almost identical to that, except for the section at the bottom of page 1, section 150. And what that language does, it basically sets forth a process where, when a county determines in its discretion that it would like to have a solicitor in the probate court, that they can go to they must go to the DA and give them what essentially is a right of first refusal to provide that service. If the DA determines that they can do that within their budget or with monies provided by the county, then they do it in kind of the normal course of business. So if they don't, subsection B would apply, and they basically create a situation where they can hire a private lawyer on contract, and then the remainder of the bill really goes through and setting the parameters for what that lawyer has to comply with in terms of conflicts, in terms of their qualifications, etc. And we can go into more detail if you'd like, but I think that sums it up pretty well.
When you get down to section 15-9-151 and following, that really comes back to what we did last year with the municipal courts and the employment of a prosecuting attorney. Is that correct?
Yes, sir.
Mirrors that provision?
Yeah, from 151 forward is essentially the language from that municipal bill that you all passed last year, except, of course, it refers now to probate.
So to summarize, if a probate court does not currently have, or even does have, they're going to change procedures, a prosecuting attorney, they will first the probate judge will turn to the local district attorney of that circuit for assistance. If the district attorney cannot provide assistance, then the probate judge goes to the local governing authority, the county commission, asks for assistance there. They will then be able to seek either through compensation to the district attorney. Failing to do that, resolving the issue, they would be able to then employ an attorney, qualified attorney, to serve as a prosecuting attorney for compensation to be set by the Board of Commissioners.
Yes, sir, that's correct.
And that person who serves has to meet all the qualifications of a regular prosecuting attorney.
Yes, sir, essentially, and that's what much of the bill covers.
Any questions of Mr. Middleton? Yes, sir.
Just one comment on
Yes,
section B, which would be on page 1, and I may be swatting at a gnat. It doesn't need to be swatted at, but if for any reason the district attorney is unable to assist, I would add that they should do so in writing. That may sound a little foolish. I was a DA for 15 years.
Yes, sir.
I had 4 counties, and you may talk to somebody and they would get upset, or they say you did call them or we did talk, And like I say, it may not be needed. I'm just saying as a former prosecutor,
Okay.
I would add district attorney is unable to assist and shall so notify me in writing.
Mr. Chairman, as you know, that language, that entire 150 is primarily there as a result of the discussions with the DA. So I would defer to them on that point. And if
All right.
I don't think the probate judges would have any objection to that.
Thank you, sir. We'll take that in consideration. Does anyone else wish to speak on Senate Bill 120 this morning? Is anyone here from the District Attorney's Council would like to talk about that?
Chairman, I'm here, but I'll answer any questions.
Okay. All right. No further public input. We'll close off further comment from the public. The Senate Bill 120 is now in the rest of the committee. Do we have any discussion on the bill by committee members? There being none, the chair will call for motions. Is there a motion on Senate Bill 120? Motion is do pass. Is there a second? It has been seconded. Any further discussion or amendments to the Senate bill? Maybe with the assistance.
I would amend line 20 after the probate court. It says assist the probate court, comma, in writing. Take out the comma and put in writing and then comma. I would make that as an amendment.
If I may,
I think we want to be a little
Well,
more
you may
specific what we're talking about there.
if I may, Mr. Chairman,
Okay.
give a
Go ahead,
simply
please.
say after court, put a comma in there and notify the same in writing, comma.
Are you trying to say that the DA is to notify the probate court?
Yes.
The governing authority?
The probate court, who's making the request of the district attorney.
We say, after court, he or she shall notify the probate court in writing?
Mm-hmm.
Yes, sir. Yes.
All right. Let me see if I can state the amendment. The paragraph B, it will read as follows. If for any reason the district attorney is unable to assist the probate court, comma, he or she shall notify the probate court in writing, comma, and the governing authority of a county in its discretion shall be authorized to create by ordinance or resolution the office of prosecuting attorney of the probate court, etc. Correct? So we're also having and the governing authority. Put the and before the that point. Okay. Does everyone understand the amendment?
Yes, sir.
You propose that as the First Amendment. Any discussion on the amendment? We have a second, I believe, to it. Do we not? Any discussion on it? If not, the chair will call for the vote on the amendment. All in favor signify by saying aye.
Aye.
Opposed? There be no opposition. Motion carries. Amendments added. Any further amendments? There being no further amendments, we'll go back to the main question, which is a motion. Oh, excuse me, Ms. Travis.
One, you also consider, on line 13 through 16, you're giving the jurisdiction to the district attorney to prosecute in the probate court under Article 2 of the chapter. But if the governing authority appoints a prosecuting attorney, you're not giving jurisdiction to that. You're not giving them
All right.
jurisdiction. You're only giving it to the DA.
I think what we might do is on line really 23 where it says authority shall have, shall have the authority to hire the prosecuting attorney who shall have the, let's see where the wording is, shall have the authority to prosecute criminal cases in the probate court as set forth in Article 2 of this chapter and Article 2 of Chapter 13 of Title 40.
I think that would work.
I'll second that amendment.
All right, let me restate the amendment so we have it clear. On line 23, we're saying, starting on 22, and the governing authorities will have the authority to hire the prosecuting attorney who shall have the authority to prosecute criminal cases in the probate court. Prosecute criminal cases subject to the jurisdiction of the probate court as set forth in Article 2 of this chapter and Article 2 of Chapter 13 of Title 40, period. That would be a proposed amendment.
Second.
Any discussion on the amendment? Now, if the chair calls for the question, all in favor of the second amendment signify by saying aye.
Aye.
Opposed, sign. No. Motion carries. Amendments added. Any further amendments? Go back to the main question. It is now motion before the committee is to do pass Senate Bill 120, LC 295625 ERS as amended and as a committee substitute. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you. Senator Stone, I saw you come in. Yes, sir.
Mr. Chairman.
You want to come around? We'll hear your two bills. First will be Senate Bill 61. Thank you, Senator.
Mr. Chairman, Senate Bill 61, which was heard in subcommittee yesterday, deals with the self-storage industry, makes four basic changes to the manner of notification of default, the manner of publication of sale, the disposal of property to satisfy unpaid rental, and an alternative remedy to sale when dealing with rolling stock. We amended it yesterday in subcommittee. The amendment took up, it can be found on lines 113 through 117, and that was to clarify to the renter in the contract that there were three alternative means of notification of default. Now, the only new one really is the email, and that's this makes clear that email notification is only in the case where it's been agreed to by both parties. Mr. Chairman, I would bring one possible concern, and that is when we use the language all notices as instead of notice of default, that we did not intend by that to take in normal billing notices that are sent by mail or other means in the ordinary course. I don't think the intent here is to require any special notification procedure for routine billing.
All right, sir. Any questions of Senator Stone by members of the committee? Yes, sir.
To rectify that concern, if we inserted other than bills and invoices after all notices, would that work?
That would cover it completely.
113.
All right, sir. And you over here, is that yours, Mr. Bruce?
Senator, this is my first chance to see the legislation, so I just want to make sure I understand what you're doing. Is it the intent to basically shrink the period of time that a person has to appeal or pay for the service that they're getting? Is that what's going on?
It makes it clear that you're in default if you're a week late on your payments. The previous or current law is 10 days. That you're not in default if you're up to 10 days. But now that's a third of a month, basically, of no rent being paid, and also a higher risk that the goods will be moved from the location, and that deprives the facility of its most meaningful means of recovery, and that is to, when someone is in default, to lock the facility so that the goods can't be taken out before liquidation.
Does it also change the notice period that the owner of the facility has to notify the renter that they are in default? Does it change that?
Well, all that's the notification cannot go out until the 7 days. In other words, that's almost like a grace period.
Thank you.
Yes, sir, Mr. Jacobs.
Just one other quick question. I found the defined term verified mail to be a little odd. I mean, what you mean here is ultimately certified mail or statutory overnight delivery, right?
That's correct.
All right.
That would encompass the other means of overnight delivery besides the U.S. mail service.
Right. I guess. I mean, I suppose I'm fine with using the defined term verified mail, but I mean any type of regular mail could provide evidence of mailing. I mean, whether it's the envelope or a receipt from the post office or something like that. So, right. if your intent is certified mail, I'll offer an amendment at the appropriate time.
Well, I think that would stay within the intent.
Right. And that's certified mail, return receipt requested, right?
Right.
Okay. Thank you, Senator Stone.
All right. Any further questions of the presenter? Is there anyone else who'd like to speak on Senate Bill 61?
Mr. Chairman.
Yes, sir.
Legislative Counsel has made a very good observation that on line 152, last known address, postal address may be too restrictive. So postal should be deleted from line 152.
Yeah.
Restaurant address is defined on line 22. That's the defined term.
Right.
Mm-hmm. That it is. All right. Further
That's all.
comments? If no further comments, the bill will close off further public comment. The bill is now in the breast of the committee. Do we have a motion? Motion and seconded to do pass. Do we have any amendments, Mr. Jacobs?
Yes, Mr. Chairman. First amendment would be on line 47. Delete and 48. Delete the method of mailing that is offered by the United States Postal Service and insert in its place certified mail, comma, return receipt requested, comma.
Where are you making your insertion for?
Right in place of that language. That we're deleting the method of mailing that is offered by the United States Postal Service.
Delete all that.
Delete all of that and inserting in its place certified mail, comma, return receipt requested, comma. And then On line 48, we would delete "that provides evidence of mailing" and place the period after statutory overnight delivery. So verified mail means certified mail, return receipt requested, or statutory overnight delivery.
There are other methods of mail by the U.S. Postal Service that provide proof of mailing without return receipt. So that's
proof of sending.
Proof of sending is what you're after there. So it may be that amendment is not needed.
Well, I mean, isn't anything that you might send at a, I mean, if once you mail anything at a post office, you'd have proof of mailing because you'd get a receipt, right?
Well, you don't always get a receipt when you drop something in the mailbox, but registered mail is another example, and you can get verification of mailing without asking for return receipt.
I'll inject my thoughts. I think everything we do within the law as far as code writing deals with a form of certified mail as
Right.
a way of being proof of it being delivered or attempted to be delivered. And if they fail to pick it up, then they've received notice, and the law assumes their refusal to pick it up is they have knowledge of its contents.
That's true.
So I think we might want to perhaps consider that as opposed to just the proof of mailing portion of it. Would you be open to that?
I would be comfortable with that.
Okay.
I'll stick with the amendment.
Pardon me?
Stick with the amendment.
All right. So let's say you got amendment, you got a second. Any further discussion on the Jacobs Amendment 1? If not, we'll vote on that. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Do you have any other amendments?
I do, Mr. Chairman.
Jacobs Amendment number 2.
Line 113, insert "other than bills and invoices" after "all notices." So I hereby agree that all notices other than bills and invoices shall be given by hand delivery, verified mail, so on. Insert "other than bills and invoices" after "all notices."
Everyone understand the amendment? Is there a second to the amendment? Second. There is a second. Any further discussion on the amendment? Jacobs Amendment number 2. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Do you have any further amendments?
Line 152, delete the word "postal."
Jacobs Amendment number 3 is on line 152, delete postal. Is there a second to that amendment? Second. It's been seconded. In discussion on the amendment. Chair calls the question. All in favor of the Jacobs Amendment number 3 signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any further amendments, Mr. Jacobs? Yours is next,
Yeah.
Ms. Jones. All right.
No amendment, just a comment if this is the appropriate time, Chair.
Yes, ma'am.
I was able to ask the distinguished senator exactly what were we trying to resolve in subcommittee yesterday with reducing the time from 10 days to 7 days. And after having an opportunity to kind of think about it overnight, my only concern is that we are putting the convenience of a handful of storage property owners before thousands of Georgians who, many of them, we're not talking about people who may just be putting their second home in storage up there just for convenience. We're talking about folks who may have lost their home in foreclosure for financial difficulties. They're moving in with other family members. And these storage properties is where all of their belongings are kept. And to cut it down 3 more days for the convenience of business owners, I think it may injure some of our indigent residents of Georgia, and so that really, really concerns me. And so I don't know if I just wish we could really reconsider whether we want to shorten it from 10 days down to
Well, that'd
7
be up
days.
to somebody proposing an amendment then on that point.
Will I move for an amendment on line 109, increasing it, changing it back from 7th calendar day to the 10th calendar day?
All right. Is there any other places in the bill that address that? I'm not sure.
Also, looks like line 82 from 7th to 10th.
92. Correct. You would do that as amendment of one amendment?
Yes,
to
if that's
change the 7th back to the 10th in both line 82 and what you're speaking of is line 108 and 109. Is that correct?
that's correct.
That's in the form of amendment. Is there a second to the amendment? It's been seconded. Any discussion on the amendment?
Mr. Chairman, is
Yes,
it
sir.
out of order for me to comment on that?
I'll allow you to comment.
Thank you. This bill was originally proposed with a 5-day grace period. The 7-day was a compromise. This is an industry in Georgia that is mainly small businesses. There are about 1,500 of them in Georgia that employ about 5,000. This is any burdens that we put that make it difficult to keep rental agreements current it is a big imposition. So I would urge that you take that into account and leave it the 7 days intact, because that was a compromise in this case.
Thank you, sir. Any further discussion on the proposed Jones amendment? All in favor of the amendment signify by saying aye. Aye. Opposed, like sign? No. Chair rules the motion fails. Any further amendments, Ms. Jones? Next we have, you're up, Ms. Weldon? He waives. All right. Any further amendments? If not, we're back to the main motion, which is a motion due pass Senate Bill 61 LC 295624S as amended as a committee substitute. All in favor of the motion signify by saying aye. Aye. Opposed, like sign. Chair rules the motion carries.
Thank you, Mr. Chairman.
Yeah. Thank you. Thank you, sir. We're going to have your second bill. Let me mention Senator Hill. We were going to hear your bill today, but I think there's some things still being done as far as potential amendments to it, and I'm going to hold it, if you don't mind, until Thursday so we have a clear understanding what may be potential amendments that go with the bill, if that's suitable to you. I didn't want to hold you up. It just came to mind. That was something we talked about prior to committee today. Okay. Thank you, sir. Senator B, you have another bill. Senator Stone's Bill 66. Senate Bill 66.
Thank you, Mr. Chairman. SB 66 provides for an increase in the maximum limit for contempt fines in superior courts and state courts. The limit has been for 30 years $500. The judges in my district have approached me, and has judges in other districts along with the state judicial council requesting that this increase be done to take into account the passage of 30 years and the fact that in order to have the same deterrent effect now that it had 30 years ago, there needs to be an adjustment. They point out to me areas of concern where fines are sometimes needed, and that includes the increase in pro se litigation, and also in dealing with corporate litigants where the incarceration option really does not have much impact.
Thank you. Questions of the senator? Let me ask, we have two types of contempt, I believe, with courts. That is, one, contempt in the presence of the court, that was in the courtroom, and then you have contempt of the failure to comply with orders of the court. Does this deal with both?
I think it would deal with both, Mr. Chairman.
So whether it's in presence of the court or failure to comply?
I don't believe there's a distinction.
Okay. Wondered about that. Thank you. We have a question over here by, is that, yes, ma'am.
Thank you, Mr. Chairman. Thank you, Senator Stone. My question is on line 27, where you've added the language, verification of an answer shall not be required. I was wondering why that was added and what the effect would be if the complaint is verified. My understanding has always been that if the complaint is verified, the answer should be verified, and I want to know if we're changing anything and why.
Representative Evans, I neglected to address that. That was an amendment in subcommittee. I believe Representative Jacobs added that. It deals with magistrate court proceedings only.
Would you like to propose your question, Ms. Evans, to Mr. Jacobs?
Sure.
All right.
Sure.
Ditto that question.
We discussed this in subcommittee yesterday. This is these two sections 3 and 4 come out of a bill that was introduced shortly prior to crossover day. We have some magistrate courts. Actually, right now in the code, answers and counterclaims are not required to be verified. The code is silent on those two types of pleadings in magistrate court. But of course, a statement of claim is required to be verified. We have a number of magistrate courts in at least in the metro area where I practice, where they will require verification of anything you file, whether it's filed by a pro se party or an attorney. Obviously, if someone files an answer or an answer and a counterclaim, they are going to have their day in court. And so it seems, well, I can see the justification for requiring verification of a statement of claim. It seems unnecessary to require, particularly if someone is not showing up in person to file an answer, for them to go and track down a notary to file an answer in magistrate court. So this would just make clear, and we are cleaning up some language with regard to counterclaims as well there in Section 4, but this would make clear that verification of an answer or a counterclaim filed in magistrate court is not required, because at the end of the day, that defendant and plaintiff are going to have their day in court.
Agree.
All right. Anything further as far as questions of Senator Stone this morning? Senate Bill 66. Yes, ma'am. Ms. Evans?
Sorry, and I apologize if I had been in subcommittee. I would have gotten these questions answered. On lines 15 and 16, am I right that we're taking away discretion of the court to decide which of these fines he might want, whether he wants to do the fine or imprisonment, or we're saying he has to do both? I'm reading it fast, but I want to know if I'm reading it correctly.
You're using the conjunction and as opposed to an or?
That's not the intent, and if the committee would feel more comfortable with or being the conjunction, I would have no issue.
I think what you want to probably have it cover is both. I mean, you could have a incarceration as well as a financial fine.
I have an amendment at the appropriate time, Mr. Chairman.
We'll recognize you at the appropriate time for the amendment.
I waive.
You waive? Okay. All right. Any further inquiries of Senator Stone? Is there anyone else who would like to speak on Senate Bill 66 that we have not recognized? Any judges want to? If not, we will close all further public comment, and the House Senate Bill 66 down the breast of the committee. Any discussions? If not, we'll take chair will entertain a motion. Motion is due pass. Is there a second? Second to it. Are there any amendments? Ms. Evans.
Thank you, Mr. Chairman. I propose at line 16 to strike the word and insert comma or, and then at the end of that line undo the deletion of or both.
All right.
It may need to be cleaned up.
If you're going to do one plus the other or both, it's defined, comma, by imprisonment not exceeding 20 days, comma, or both. You don't need the or. You just need a comma after 1,000 and take out the word and.
Yep.
Okay, so what we'll say is the punishment of contempt by fines not exceeding $1,000, comma, by imprisonment not exceeding 20 days, comma, or both, semicolon. That proper state your amendment, Ms. Evans?
Yes, Mr. Chairman, thank you.
All right. We've had a motion and a second. We have a question, inquiry?
Just a quick question on that amendment, probably for Ms. Travis. I assume we don't need to do something similar on lines 10 and 11?
We're going back to that in the second one.
Okay, we do. Okay.
We're going to go back to, if somebody wants to do that, that will be the next one.
All right, sounds good.
Any further discussion on the Evans Amendment 1? If not, the chair will call the question. All those in favor of Evans Amendment 1 signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Any further amendments?
Mr. Chairman.
You can push your button for me? All right.
Have a motion to amend. On line
State your
10,
amendment.
line 10 it reads, to punish contempt by fines not exceeding $1,000. I propose we move we delete the word and, put a comma after the $1,000, and then so it'll read $1,000 by imprisonment.
Right. And by imprisonment not exceeding 20 days, or comma, or both.
Correct.
Then semicolon. Okay.
Yes, sir.
To match up with what we did with the first amendment.
Yes, sir.
That is the Weldon Amendment. Do we have a second? It's been seconded. Any discussion on the amendment? Chair will call the question. All in favor of the Weldon Amendment signify by saying aye.
Aye.
Opposed, like sign. Amendment carries. Any further amendments? Mr. Jacobs.
Just to clean up the title a little bit, on line 3, after answer, insert or counterclaim.
That is a change in the article statement, and that is on line 3, provision relating to the filing an answer or counterclaim in magistrate court, semicolon. So we're adding or counterclaim. Is that understood? Been motion made, Jacobs Amendment, and seconded. I believe Mr. Weldon, was that right? Yes. Any discussion on the amendment, proposed amendment? On the Jacobs Amendment, all in favor signify by saying aye.
Aye.
Opposed, like sign. Amendment carries. Any further amendments? Not. We'll go to the main question, which is a due pass of Senate Bill 66, as amended as a committee substitute, LC 295623S. All in favor signify by saying aye.
Aye.
Opposed, like sign. Motion carries. Thank you.
I appreciate the efforts to improve
You see how we work. we try to put out good products. I think that completes our calendar today. I think we're holding up 179, but I want to say to the committee members, if you would like to wait, we have lunches coming. Your benevolent chair has bought lunch for all of your committee members. Yes, sir. Mr. Bruce. Pull your mic around.
There were people earlier that were advocating for the passage of marijuana laws, and it's a strong scent of marijuana in this office. Was there a sampling or something going on that we don't know about?
I have. Either my senses are failing me. I don't know what marijuana smells like.
Yeah, right. The lobbyist told me.